is serving as our keynote, Bisexuality and the Law. And we have three people presenting the keynote. So I'll go ahead and introduce them each individually. Nancy Marcus is first, and she is an associate professor of law at California Western School of Law, where she teaches courses including sexuality, gender identity, and the law. She earned her JD from Case Western Reserve Law School and her LL.M and S.J.D from the University of Wisconsin School of Law. In addition to her academic work, she has been a constitutional litigator, a judicial law clerk, and a policy advocate, including as a Lambda legal attorney and as a state public policy director for the National Abortion Federation. These are just kind of shorter versions of the bios if you all want to add more, but just for the sake of brevity to get the presentation started. Uh, El Eliot Tracz is next, who is an assistant professor of law at New England Law Boston. He teaches courses in property law, intellectual property, and sexual orientation, gender identity, and the law. Prior to entering academia, Professor Tracz served as Associate General Counsel in the office of Governor Tim Walz and Lieutenant Governor Peggy Flanagan in Minnesota. Professor Trax's research focuses on issues of sexual orientation and gender identity with particular interest in First Amendment protections, as well as the intersections between bisexuality and the law. And finally, we have Anne Tweedy, who starting in August, so about last month, will be a professor of law at the University of Mississippi School of Law. Prior to that, she was a professor of law at the University of South Dakota Knudsen School of Law. Professor Tweedy is a nationally recognized scholar on tribal civil rights law, tribal jurisdiction, and bisexuality and the law. Before coming to USD, she served as an in-house attorney for Muckleshoot Tribe, and she also previously served as an associate professor at Hamline School of Law, which is now known as Mitchell Hamline. So without further ado, I'll leave it to our three presenters to kick us off on our keynote for the end of the day. Thank you so much, all of you, for being here.
Thank you so much for the introduction, Gabrielle, and we are so humbled and grateful to be here presenting the keynote and wrapping up this amazing conference. And to all of you in chat who are talking about how old you are in your 40s, can I say the 50s are the niftiest? And because I'm old, I will therefore claim the privilege of not having a PowerPoint presentation, but presenting old school. So we are really pleased. Anne and Eliot and I are all law professors in the United States, and we're really excited to begin our presentation with an announcement that Cambridge University Press has entered into a contract with us to publish the first academic textbook in the United States on bisexuality and the law. It'll be Cambridge Companion to Bisexuality and the Law, coming out in a couple of years. So we're very excited about that. And our keynote presentation will be talking about what we're planning to write about in our pending book on bisexuality and the law. And Cambridge University, we couldn't be more thrilled. As you probably know, it is the oldest university press in the world. So we're really, really honored to have that opportunity to spread the word globally about the importance of bisexuality in legal contexts. So we are going to share briefly what we're going to be writing about in our pending book. We're going to start with Eliot, who will be describing some of the foundational chapters on bisexual demographics, intersectionality, and relation structures as it relates to legal issues.
All right. Thank you, Nancy. And I apologize in advance. I'm losing my voice. It's allergy season for me. So if you can't hear me, shoot a little note in the chat and I'll see it and I'll try to do better. So I'm really excited to be speaking with all of you, and it's been a real pleasure to go through the beginnings of this process with Anne and Nancy, who are both important parts of my chosen family, and who I'm just really glad to have the opportunity to work with. So I'm going to talk quickly about three different topics. I'm going to start with what it means to be bisexual, which of course means something different to all of us. But in the law, trying to pin down a definition is particularly important. And then I'm going to move on to bisexuality and intersectionality. And then finally, really quickly, talk about bisexuality and relationship structures, at least within the United States. So first, we all know bisexuality is not an easy thing to define, even though it may seem somewhat simple on its face. So for many of us, we may describe our identities in different ways at different times during our lives. Some of us may never waver. And that's all very normal, but at the same time, that fluidity presents a little bit of a legal challenge. I think Ann and Nancy would probably both agree with me that many of the best statutes and ordinances contain definition sections um, to sort of point us in the direction of where we need to be going and how we need to assess facts. So at the same time, law has never yet defined what bisexuality is, which can have legal consequences for individuals who appear before judges who either lack knowledge or an interest in obtaining knowledge about the lived experience of bisexual people. So while I personally have always preferred Robin Oak's description, I call myself bisexual because I acknowledge that I have in myself the potential to be attracted romantically and or sexually to people of more than one sex and or gender, not necessarily at the same time, not necessarily in the same way, and not necessarily the same degree. I don't think that that's quite legally sufficient. So there might be three things we would look at typically in determining whether someone might be bisexual. So the first would be objects of desire. So there we would be considering who you might be attracted to. So someone exclusively attracted to the same sex might call themselves gay or lesbian. Someone exclusively attracted to a different sex might call themselves heterosexual. And then a bisexual person might fall somewhere in between. And if you've looked at the Kinsey scale or the Klein grid, I tend to include everything that's not either end of the pole to be bisexual. Um, for some of us, there might be a distinct preference for one gender or another. Um, and then, we can get it even more complicated and say I might experience romantic attraction to one gender, but sexual or physical attraction to multiple genders. Um, Second, we might address behavior. So under this approach, we would look at the sex or gender of a person's current or previous partners. But that, of course, presents its own challenges. For example, it effectively discounts minors or people who have no experience in intimate relationships. It also doesn't necessarily account for people whose personal experience is only with a person of the same or a different sex. And then third, we have self-identification, which is probably the easiest way to assess sexual orientation since it relies on self-reporting. But then again, that's also its problem. It hinges on individuals being willing and able to self-report. And data has shown us that for people who identify as bisexual, we're less likely to come out or identify publicly. And so our demographic data, based on self-reporting, is likely underrepresentative, which presents its own challenges. So I'm personally of the opinion, I haven't run this by Ann or Nancy, that it's some combination of the three is probably the best way to assess bisexuality from a legal standpoint. But one of the things I'm hoping that our book can come together is to provide a definition for courts and administrative agencies moving forward that they can use to identify or to address the needs of bisexual people. So then I'm going to talk quickly about intersectionality. So of course, a person's identity doesn't merely end with the acknowledgement of their bisexuality. We can be bisexual and Black, as I am, bisexual and disabled, bisexual and transgender, or any other of an unimaginable number of combinations or attributes, which bisexuality is merely one factor. But I think this is somewhat of an easy way to address intersectionality and can sometimes be somewhat of an oversimplification because intersectionality investigates how intersecting power relations influence social relations across diverse societies and individual experiences. So it might view categories of race, class, gender, sexuality, nationality, ability, ethnicity, or age as interrelated and mutually shaping one another. But I also think that analysis can be taken to investigate as well relationships within the LGBTQ community. And I think that necessarily requires looking at power dynamics within sexual orientations and privileged identities. And so when I talk about privileged identities here, I include heterosexuality because it is often treated as the de facto normal sexual identity. But I also include homosexuality on the other side of the. I really hate to say binary, but for easy purposes here, I'm going to go with it. And please feel free to like hate me. I include homosexuality in part because of the hard work and advocacy that has gone in and the sacrifice of others that have come before. Bisexuality again falls somewhere in the middle. And I think the clearest way to see in which these two privileged identities, heterosexuality, homosexual, or well, gay or lesbian identities, overshadow bisexuality is when people who are bisexual are assigned a sexuality based on the sex or gender of their romantic partner. I think it's also worth mentioning here briefly the concept of passing privilege. And some people I know just refer to that as the ability to pass for straight, but I also include the ability to pass for gay or lesbian. And what I find makes this assertion particularly odd when it's applied to bisexual individuals is that this action that is deemed for us to be a privilege would be identified as being in the closet for anyone else. So I'm going to finish up really quickly by talking about, just mentioning that since the decision in Obergefell, the relationship structures have changed for people in the bisexual community. But a big development recently in states like Massachusetts and now, at least in one jurisdiction in California, is legal representation for polyamorous families as well. There's not a lot of data there, but I just want to bring up that that's something we'll be covering, and hopefully we'll have more data as the book goes to print. So with that, I will turn it over for the next session.
Yes, so thank you so much, Eliot. And as you've all seen, bisexuals really do represent a huge percentage of the LGBT population, even more so than those who identify as lesbians and gays. But with bisexuals constituting such a large percentage of the population, you really wouldn't know it from our visibility in legal contexts. In the United States, I was excited when I was a law student back in the 1990s when Rummer versus Evans came out, the first United States Supreme Court opinion affirming gay rights, quote unquote. And originally, what was being challenged was an ordinance that on its face singled out lesbians, gays, and bisexuals, saying they couldn't have civil rights protections. But in their briefings to the United States Supreme Court, our own advocates said the only people harmed by this are gays and lesbians. So we're going to call the classes of people affected gays and lesbians only. And the Supreme Court again said, okay, so the text of this amendment says gays, lesbians, and bisexuals can't have civil rights protected. But clearly the only people affected are gays and lesbians. So that's the class of people we're talking about. So Rummer versus Evans, on the one hand, marked this wonderful moment when there were rights being affirmed by the United States Supreme Court. On the other hand, bisexuals were literally erased from the briefs to the court, from the court opinions themselves. And from that point forward, bisexuals continued to be erased over and over again by court opinions, by our own lawyers in briefs to the courts trying to protect the rights of LGBTQ people. So why does it matter? A lot of people, when I first started talking about the problem with bisexual erasure, people would say, well, what's wrong? Who cares? You get the same rights as everybody else, the same rights that gays and lesbians get trickle down to you. Why is this even a problem? So what I started uncovering, and what I will be uncovering in more detail in our pending book, is the harms that result from bisexual erasure in a legal context. And some of it is not as tangible in the sense that when we aren't mentioned in LGBT rights rhetoric, but the lives of gay men, lesbians, and transgender people are addressed explicitly in comparative depth, then the message being perpetuated by such erasure is that bisexual people don't have equal worth. We don't have the same kinds of issues in common with LGBT community members. Even if we're dating somebody of the same sex, you would think, that people would recognize we face the same kind of discrimination. But when we're erased from the face of LGBT rights discourse, then judges and adjudicators also are not educated. They are not familiar with who we are as a community. They are not familiar with bisexuality as a valid sexual orientation. And so some of the tangible legal repercussions of our erasure, of our invisibility, come in the context, for example, of family law and asylum law. So, for example, in the context of family law, bisexual parents too often are at risk of losing their children in custody battles and foster care adoption scenarios because traditionally, over time, bisexuality has been viewed as by way too many judges as a proxy for instability. So you will have, one parent weaponizing the other parent's bisexuality, saying, "Well, they used to be married to me and I'm a man, and now they're with a woman, and that's not good for the children. That's unstable." And too many judges have agreed over time and taken away our parental rights because they don't understand bisexuality as a valid sexual orientation. And the more we're erased, the more those kinds of dangerous results in court are perpetuated. So, speaking of danger, asylum is another example where the dangers can be life and death. So in 2018, I very much need to update my research on this. So I am going to end with a call for people to send information to me so we can put more up-to-date global information in our pending book. But in the 2018 article on the global problem of bisexual erasure in litigation jurisprudence, I described the general problem of bisexual erasure and how bisexuals are not appearing on the face of the law, legal briefings, court opinions worldwide, but also in the context of asylum. What happens is if a bi person is seeking asylum in a country where they're trying to get refuge from a country where people are persecuted for the sexual orientation, too often the asylum adjudicators deem them not gay enough or simply disregard bisexuality as even valid or a recognizable sexual orientation for which we are persecuted in some countries. So one of the most disturbing examples of this was the case a decade ago of Horatio Edwards, a gentleman who was seeking asylum from Jamaica, trying to get asylum in the UK. And the British Home Office was very skeptical because he had once been married to a woman, even though he was in a 2-year relationship with a man. They did not believe that he was bisexual until he produced photographs of himself being physically intimate with his male partner. And that's what it took for him to get asylum. And that would never happen, right, to a gay person or to a straight person. I mean, it's just, but that's the kind of way that we're singled out. So there's been there have been a couple of court opinions in the United States where judges have just said, bisexuality, not a real thing, not something we're going to grant asylum for. It doesn't make sense. This person was married to one gender, then to another gender. We're not buying it. On the other hand, some judges have started to speak out about that and say this is absolutely the wrong way to look at it, but they haven't been in the majority. So as a result, sometimes in the context of asylum, and Sean Rehog, I'm not sure if I'm pronouncing his name correctly, he did a great report in 2009 called Bisexuals Need Not Apply, a comparative appraisal of refugee law and policy in Canada, the United States, Australia, and South Africa. He examined how disproportionately fewer bisexuals seek asylum, and when they do, disproportionately fewer bisexual asylum refugees are granted asylum as compared to gay and lesbian asylum seekers. So I whipped through that kind of quickly, but that's just a really nutshell of why bisexual erasure is dangerous when it comes to laws and legal protections. I'm going to circle back to this at the end, but first I want to turn to Anne with the turning this to a more positive light. We haven't been completely invisible. So Anne is going to be highlighting some examples of how bisexuals have appeared in legal contexts and bisexuals in the law more broadly. So over to you, Anne.
Thank you, Nancy. And I want to echo Eliot's comments. I'm really excited to be working with Nancy and Eliot, and thankful to everyone that's here and to the Bisexual Research Group for inviting us. So I wanted to talk briefly about two of the sections in our book, one about double discrimination, which has been touched on already, and then about bisexuality in legal contexts. So I'll focus there on employment discrimination. But as Nancy mentioned, we're also looking at asylum, family law, and then criminal law as well. So one of our chapters is going to explore the phenomenon of double discrimination and the fact that bisexuals are discriminated against by both the gay and straight communities. And so this is well documented in social science literature, and there are articles from the US as well as various other countries, Canada, England, as well. And there's a particularly great article by Lori Ross about the experience of bisexual respondents in Ontario, where she talks about how negative mental health outcomes are tied to discrimination, including this double discrimination. And of course, bisexuals face disparate mental health and health outcomes, and including more frequent mental distress among bisexual women, even compared to lesbians, and more likelihood of living in poverty. So some economic impacts as well, higher rates of suicide ideation than gays and lesbians. So we want to unpack that double discrimination, and we'll look at some cases that have addressed that. So on the favorable side, there's one case called Roberts versus United Parcel Service, where the court actually explored the double discrimination issue, even though it wasn't directly at issue there. But there's also an unfortunate case out of Washington State Federal District Court there called Apalato. It's kind of a mouthful, Apalato versus North American Gay Amateur Athletic Alliance. And so that case involved a gay softball league that was claiming that its bisexual players on a championship team were actually straight, and so rendering them ineligible to compete or to claim their victory. And it was great that National Center for Lesbian Rights sued on behalf of the bisexual softball players, but the judge did have a really problematic ruling where he talked about the fact that it was okay for the gay softball league to favor gay players, so erasing their bisexuality, not realizing that this was a double discrimination issue. That case did eventually settle, so there's a sort of a happy ending there. And then the second part of the book that I wanted to talk to you about is the part where we're going to look at the appearance of bisexual litigants in various types of cases. And so I'll focus here on employment discrimination. That's where I've done the most work. And you've already heard a bit about the asylum context, the family law context. And again, we're looking at criminal law as well. And we'll also be looking at evidence and whether evidence of somebody's bisexuality can come in to a case, even though it could have prejudicial effects. So there's some case law on that as well. So in terms of employment discrimination, Dr. Karen Yuskavage, who's a psychologist, and I had done an article and conducted a survey a few years ago about bisexuals' experiences with employment discrimination. We found that they sue or even complain internally only very rarely. And this was specifically related to their sexual orientation. So there were only a very small number of cases at that point when the article was published in 2015. It does appear that in the years leading up to the Bostock versus Clayton County case, which in the US recognized sexual orientation discrimination as a type of sex discrimination, the cases were already ticking up a bit before that case and then continued to rise in numbers afterwards. But generally, I would say that bisexuals sue less often than for employment discrimination based on sexual orientation, even than heterosexuals. So that's a really interesting fact. So I just wanted to spend my last couple of minutes talking about two employment discrimination cases involving bisexuals. So the first one is a very old one, the oldest known one in the United States, involving Marjorie Rowland, and then a new one that's actually very similar, just a couple of years ago. So Marjorie Rowland was a bisexual guidance counselor in Ohio, and she was fired when she acknowledged her bisexuality to her secretary, and this was back in 1975 that she sued. So she was suspended, first of all, suspended after acknowledging her bisexuality. Eventually, her contract was not renewed. And when the court ordered her back to work during her suspension, she was put into this no contact situation where she couldn't work with school kids at all. Amazingly, she did prevail at the trial level, but the Sixth Circuit reversed, and it was a very results-oriented decision with several glaring legal errors. Supreme Court denied cert, but Justice Brennan wrote a dissent that was eventually very influential, kind of didn't get much attention at first, but eventually was influential in the lower courts. And then a remarkably similar case cropped up in 2019 and then settled in 2024. And that involved a choral teacher in Kentucky who his contract was not renewed when he came out on his private Instagram account as bisexual. And the reason that he did that was because he noticed that many of his LGBTQ students were really suffering emotionally, and one had planned to commit suicide. He and police were able to interrupt that, but in response to noticing these very disturbing issues, he decided to come out on his Instagram account. And so originally the case was dismissed because that Bostock case that recognized the ability of someone to sue for sexual orientation discrimination hadn't yet been decided. But he appealed, and it was decided, well, it was on appeal. Well, his case was on appeal, so his case was then reinstated. And the school district, unfortunately, engaged in these very dilatory tactics, not answering discovery requests, and for over 2 years. But eventually the case was scheduled for trial in August 24, and literally like the day before the case settled. So it's very interesting that the same sort of case, and it was even in the same circuit, was pending so many decades later. And I know we're almost out of time, but I just wanted to leave you with a quote, or maybe I should just turn it back to Nancy to talk about the bisexual bridge issue that she wants to talk about.
Yeah, thanks, Anne, because I really do want to end on a positive note, because as much as we faced by erasure and various, problems and harms as a result, on the flip side of that, being more bi inclusive in the law can lead to bridge building and moving beyond false dichotomies and binaries, right? So like trans and gender fluidity, bisexuals can help illustrate, even within a legal context, the limitations of putting people into these false dichotomous boxes, and help create a vision of jurisprudence, even the law, that more accurately reflects the lived experiences of people. We live in gray areas. We live in spectrums, fluid spectrums that include, sexuality as a more fluid spectrum. And so it's important for the law to reflect that. And we can help open those doors and those dialogues to help, facilitate those breaking down false binaries, not just in our context, but across the board. So we do want to end with a call for input from all of you, because like I said, this book is coming out. We're just now embarking upon it. I am updating research I did 10 years ago on global problems of bisexual erasure and global examples of bisexuals, in the law and outside the law. And I want to include all of your stories from all of your countries. So I'm going to put my email in the chat box. And I would really love for you to send me examples, things that are citable that we can put in our book of bisexuals either appearing in legal context or being erased from legal context, because we want to represent you. We want to tell everybody's stories. This is a great opportunity for our story to be told globally in contexts that matter, where the laws can help evolve and improve to be more inclusive of our lived experiences. So please don't be shy about staying in touch with me. In the future, I want to do as good a job as I can be, including everybody's lives and stories. So thank you again for giving us this great opportunity to talk about our book that's coming out. Probably not for another 2.5 years, but we'll keep you posted.
Thank you so much to the three of you. This was a fantastic way to end our more official program. Super illuminating and fascinating. necessary things for all of us to know. So thank you so much. We'll all keep an eye out for your book coming out in a couple of years probably, but we'll all be tuned in. So thank you so much for sharing all of that with us. It was really, really wonderful.